All right, now to a water fight in Grant County, a great big, very expensive water fight headed to the Supreme Court the 1st of October. It has been nearly a decade since this fight began between this Grant County farm, Foughty Farms, and the Washington Department of Ecology. Now, this fight with Ron and Robin Foughty centers around water use on their farmland near Moses Lake. And ecology basically saying that the Fodeys didn't have any right to water the crops. Now, most crops they grow, it's kind of a rolling hills. I think it's about 4,000 acres. They need ample water there delivered for irrigation. They only get about 8 inches of water every year in that part of the state. So obviously, if you're growing very, water intensive crops like potatoes and alfalfa hay, some other crops that they have farmed for many years, they need a lot of water. So it was January of 2017. So again, nearly 10 years ago, they applied as they did every year to transfer water rights. This was just sort of a process you had to go through each year, get permission to transfer water rights from one area to another. And apparently, then February 14th of 2017, Ron Foughty gets a call from the hydrologist basically saying, your deadline is tomorrow for all this to be done. You haven't complied and you can't use your water. Well, at that point, they got crops in the ground. And that's when the real fight began. And ultimately, this ended up being fines leveled against 40 farms in excess of $618,000. But now the state Supreme Court is taking up the case. So I chatted last Friday with their attorney who's taken the case pro bono from Pacifica Legal Foundation. This is Allison Daniel.
So if they suspect a violation of the water rights or somebody is already violating the water rights, then they have to provide a way for a water user to come into compliance. It's a system called sequence of enforcement. The legislature determined that assistance is required first before penalties are imposed. So we are arguing that those are interconnected, these two issues, and ecology violated both. Um, they made up this statutory or this deadline without going through proper rulemaking and then foreclosed the compliance pathway that Ron could have accessed in order to obtain water rights to lawfully irrigate the property at issue.
Now, the Fodeys really have been bankrupted by this decade long fight. They used to farm Timothy hay, alfalfa, potatoes, and other crops, both for domestic and international markets, but they've really had to scale that all way back. As you can imagine, banks tend to shy away from loaning you any money for new equipment or, that's how farming works for the most part. You have to take these loans out, and then, of course, then you can pay them back when the crop uh, you know, a harvest is done and you're getting obviously compensated then for what you've produced, but it's been a difficult battle for them. So I caught up again last Friday, the same time I spoke with their attorney. I spoke to Ron and Robin Foughty.
I think for us, it feels like justice. The DOE has so many, like a lot of different departments, unvoted on people who work there. We don't even know who the people were that came out to our property and so-called measured, looked at water, if they went to the right property. There's just so much in question. And these people who are bureaucrats who are not voted in, who are making decisions of power all over the United States, and especially in agriculture where we grow food that everybody eats, and deciding what will stand and what won't stand. So for us to be heard, for the Pacific Legal Foundation to take us on and feel that this is important, speaks to all water users, people who have water rights. It really says a lot because more and more of this is happening and people need to stand up and take notice. And I'm grateful for the Pacific Legal Foundation coming in and standing with us. I was grateful for our previous two attorneys. But this is really something for all people in this kind of situation. And that maybe now, Carlene, like you, actually asking us questions, and I really do appreciate it, maybe the right information will get out there. Because for so long, I would say for 9 years, we just took it. We were told not to say anything, don't get on the bad side of the government. Well, we kind of already are. If you're in a lawsuit, you already are. And we really can't lose anything else. I mean, we've had to sell everything. The legacy has been cut off of his family's generation.
Yeah.
Yeah. So we feel grateful. I don't know how it will come out. I know our state. I have confidence in Pacific Legal, and I feel hopeful, but that's not where my hope is at.
Well, it feels good to have a big team, and we haven't let go of the other two lawyers. In fact, I just talked to Steve yesterday, and then the other lawyer, Tom, that took over the case, he's co-counsel. So really, we have a lot of faith in everybody we're working with. It feels like a big team finally, instead of just me, Tom, and my family alone. But I never realized that until Pacific Legal came in. It's like, wow, I'm really well supported. And then we got all these amicus briefs coming that support us also.
Now, the Foughtys have lots of support for their case. There have been many, many amicus briefs filed with the state Supreme Court in advance of these arguments. Those are like front of the court briefs to kind of buoy the case for the plaintiffs here. And one of those has been filed by the National Federation of Independent Business. NFIB has gotten on board with the Foughtys. They believe this is a hugely important case for small business, for small ag and farmers, like the Foughty Farms case. And so this is Rob Smith with NFIB, one of their senior attorneys.
And Mr. Foughty here is like a lot of our members. I mean, he is a member. A farmer who is seeking to do everything right. He is trying to use or obtain the water rights, available to him through the proper channels I'm pretty sure in this instance, it was to grow potatoes on the land that he was leasing. And, you just had a government agency, which unfortunately we at NFIB see too often, just telling him no, not trying to help him, not trying to, work with him in accomplishing those goals. And the government agency, in this instance, Ecology, just coming in and saying, no, you don't have these rights, even though there's a statute that says, we're supposed to help you. The legislature said, that we're supposed to provide assistance. We're just not. We're just going to tell you you have these rights. You don't have these rights, excuse me. And that's the end of what we're going to do for you. And just, for Mr. Foughty and other small businesses, including farmers in Washington, I mean, that's just not how it's supposed to operate.
Now, according to a June 2017 news release from the Department of Ecology, which was emailed to me back in May when I first reported on this case, they believe the Foughtys are in the wrong here. We'll put this up for you. The Washington Department of Ecology issued cease and desist orders requiring the landowners and the lessee to stop pumping groundwater. Ignoring the orders, they continued pumping water illegally for 3.5 more months to water 530 acres of crops. And they cite the Odessa aquifer, which has been rapidly declining since 1980. They say that groundwater has dropped more than 200 feet, forcing local farmers and homeowners to drill wells deeper to reach the diminishing water supply. So again, this case is going to the state Supreme Court. I'm going to be putting up an article on this at our Center Square Washington page. And before that, I hope to get an updated statement from the Department of Ecology, because when I received this prior statement from them, citing their release from 2017, they didn't know if the state Supreme Court was going to hear the case or not. So now that we kind of have some more attention and importance to this case to be considered in October, I want them to have an opportunity to provide further comment. So I will include that in my article at the Center Square Washington page. All right, yesterday we shared an update on a PDC complaint that was filed against Let's Go Washington back on May the 12th. The update is because the Public Disclosure Commission is moving into its next phase. They held a hearing last week in the case, which is routine after 90 days. If they think that there's potentially any merit to the complaint filed, they move ahead, they hold a hearing, and that's what happened last week. There were some TV stations that ran with it as if it was a new complaint, and that didn't go over very well with Let's Go Washington or Undivided podcast producer Brandi Kruse. And they were concerned, basically, the TV stations that ran with the story didn't even reach out to them for comment. They are at the center of this complaint filed by Pam Stewart. Again, she's a Sammamish City Council member, and she's been a pretty vocal critic of Let's Go Washington's initiative. In fact, we shared in yesterday's episode that she was accused of sort of getting in the way of some folks who wanted to sign petitions for the income tax repeal, I-645. That happened back in late May at a Safeway store in Sammamish. So we talked about that today, but her complaint is basically contending that every time Brandi Kruse on her podcast talks about the Let's Go Washington initiatives, and in this case, we are talking about the parental rights initiative to restore parental rights in education. So the school has to tell you if something's going on with your kid. And the protection of girls in sports, keeping trans identifying athletes out of girls' sports. Those two initiatives Brandi's very passionate about and has spent a lot of time on her show, if you follow her, talking about those. So the complaint from Pam Stewart alleges that there have been at least 150 instances where Brandi has talked about these initiatives on her show, and that should be treated as an in-kind contribution to Let's Go Washington, basically an advertisement for those initiatives. So I didn't get a hold of Pam Stewart yesterday, but she did phone me back this morning. So I've updated my article published yesterday on the site to include some of her comments. But I wanted to share with you a little bit about what she said and a couple of the quotes from our conversation. We'll put this up for you. She said, the main goal here is transparency, right? I think in today's world, it's really important for people to know who's providing services, who's paying for things, so that they understand the information that they're getting and what that source is. Is it truly unbiased? Is it, a personal opinion? Is it a fact? To me, that's really important in today's world. And I think that's what we're all looking for, is just some transparency. So she mentioned that. And then she shared that she's also convinced Brandi Kruse is actively campaigning for Let's Go Washington. And she said, Brandi's way more involved than she should be. She says it isn't like she just had one episode where she talked about an issue. She's participated and been the MC at Let's Go Washington events. She's using her following and her followers in that way. She's pretty actively campaigning for these initiatives, and that seems pretty obvious given the number of times she brings it up. Again, that was in my conversation this morning with Pam Stewart, the Sammamish City Council member who filed the PDC complaint alleging that Let's Go Washington is either funding Brandi's campaign, which both she says they aren't and they contend they aren't. But she also took issue in our conversation with a post that Brandi put up yesterday. Of course, this has been heavily in the news since late last week. And the post from Brandi on X yesterday, we're going to share with you in a moment. Again, she was responding to the PDC investigation and repercussions. She says if they end up finding that her talking about the initiatives amounts to an in-kind contributions, that really is going to open up a Pandora's box here. If this ends up being a successful complaint, that there would be far-reaching impacts for members of the media all across this state.
And if suspicion is enough, the PDC has the power of subpoenas. They can subpoena my records, my personal information, my financials, based off of what? A hunch? A suspicion? Okay, if you say that suspicion is enough to get news entities to open up their books, Well, I suspect that the Seattle Times, since it takes advertising revenue from the Washington Education Association, that advertising revenue is actually being used to pay them for favorable reporting. I suspect it. Bring them in, subpoena them, make the Seattle Times open their books. And we'll do the same thing to every single commercial advertiser working in the news sphere. And it will cost them hundreds of thousands of dollars, hundreds of hours in attorney fees, and it will render the PDC essentially useless. Try me. Try me. I will spend every waking hour I have burying the PDC in absolute bullshit over this. And Pam Stewart, in the Washingtonians for Ethical Government, Pam, you are on a razor-thin line of defamation. Razor thin. For one, you take one freaking step over that line of accusing me, again, of doing something that I have not done, taking money I have not accepted, getting handed money behind the scenes, to what, say men aren't women? Men aren't women, men aren't women, men aren't women, men aren't women. So we will raise holy hell in this state. We will bury every newsroom in PDC complaints, in legal work, if this is the route they choose to go. And I will be tireless in my pursuit of retribution.
So there is that. Pam Stewart said she took offense to that post from Brandi and likened it to a personal threat against her. So much more to come, I'm sure, on that. And there's no idea at this point when this will be resolved. By the way, the PDC indicated to me yesterday there's no timeline for resolution here. And resolution could look a number of different ways. It isn't necessarily going to be a fine if they find any in-kind contribution in favor of the person who filed the complaint. Or they could simply say to Let's Go Washington, okay, you can't do this, or Brandi, you can or can't do this. There could be a number of different courses if, in fact, they find the complaint to have some validity. But I want to remind you that there was a case concerning KVI radio hosts, both John Carlson and Kirby Wilbur, in this 2007 case. And in full disclosure, I worked for KVI at the time. I recall a lot going on when this case went to the state Supreme Court. And it was called, I want to read this, San Juan County versus No New Gas Tax. And this was a complaint that basically said these talk radio hosts are going on and on talking about the No New Gas Tax initiative. They should not be able to do this. They're campaigning for it. And the Supreme Court found that it was legally protected speech for these talk show hosts, ruling that it didn't violate state campaign finance laws, or that disclosures needed to be filed with the Public Disclosure Commission every time they talked about them. So it's almost as if this has already been decided by our state Supreme Court. Pam Stewart said she believes it's a different world now. And granted, the social media influence nearly 20 years later, and how podcasters are influencing news content that people absorb, it's a whole different landscape. So we'll see if the PDC takes that previous Supreme Court ruling into consideration or not, if they consider it to be something entirely different. All right, let's dive in. We've got PDC complaints piling up with 2 new grievances this week. One is filed by radio host Ari Hoffman, but not in his capacity. He's not using, his position at KVI. He's filing as a private citizen. And this is directed at the Seattle Times and related foundations, alleging that the publication may have crossed the line from journalism into reportable campaign activity related to coverage of the No on 2117 campaign. Again, 2117 was the initiative on the fall ballot in 2024 that asked voters, do you want to keep the Climate Commitment Act? Do you want to repeal it? Ultimately, voters decided to keep the Climate Commitment Act. But were they swayed in any way by some of the coverage from the Seattle Times and their Climate Lab and Seattle Foundation and some of these other funded organizations that wrote multiple articles in the Times and their editorial board as well. So here is part of my conversation about the PDC complaint filed by Ari Hoffman. I talked to him last evening.
So the Climate Commitment Act was the people who were working to keep it in place were groups like the Seattle Foundation. And those groups are the same ones who fund the Climate Lab in the Seattle Times. The Seattle Times has been losing subscribers for years. The way they're staying afloat is they get these donors to pay for these special sections, the Climate Lab, the Education Lab, Project Homeless. So the people who are sponsoring this thing in the Seattle Times are also the ones behind the opposition to repealing the Climate Commitment Act, which, don't forget, spiked our gas prices by a huge, huge amount. So if they're paying for this thing and they're working on the campaign, they're basically, most people don't look at the fine print that say that this is paid for by the Bill and Melinda Gates Foundation or Seattle Foundation or whichever one is funding whichever one of these specifics. They don't look at that. They just see an article in the Seattle Times. But worse than that, one of these groups was putting the content in the Seattle Times so then they could push it out for the campaign of look what the Seattle Times says. So this was all undisclosed campaign contributions. And I think that's a much stronger case than the one that was filed against Brandi Kruse and Let's Go Washington.
So he was referring there at the end to the May 12th complaint, May 12th of this year, that was filed by Washingtonians for Ethical Government and that organization's communications liaison, Pam Stewart, against Let's Go Washington. We've talked a lot about this over the last week or so. Pam Stewart alleges that podcaster Brandi Kruse's support for Let's Go Washington initiatives amounts to advertising for the organization, like a campaign donation. And, she suggests it needs to be reported as such for campaign donation purposes. So the other complaint, it was filed just today, just this morning by Arthur West, and it's directed back at Washingtonians for Ethical Government and their staff members, including Pam Stewart, accusing that organization, which defines itself as a watchdog group, of failing to register as a political committee with the PDC, despite years, he says, of active activity directed specifically at defeating conservative ballot measures and supporters. That's really what they go after. They have targeted Tim Eyman in the past, or Andrew Villeneuve, their president, has targeted Tim Eyman in the past and some of his initiatives going back many, many years. So he is suggesting, Arthur West is suggesting in this complaint that really, this stuff needs to be reported and that they need to be investigated. As I mentioned in the opening, West is the same guy who is behind the current appeal before the state Supreme Court, no decision, to the Public Investment Impact Disclosure Statement written by AG Nick Brown's office that will appear next to the income tax repeal attempt on the fall ballot. That's I-645. So the contention from Arthur West and others who've challenged the PIID is that it's inaccurate. It's, not informing voters of the right thing. So they've been challenging that. And again, that's an appeal that is currently before the state Supreme Court for consideration. There have been a number of legal filings, both in support of West's appeal and from groups opposing that. And then the way these things all work, then, they file the amicus brief, say it's in support of it. Then another group gets to come back and file a legal brief that says, this is why we think this is a bogus, amicus brief. Of course, I'm simplifying it because I'm not an attorney, obviously. So let me give you a little bit more about Hoffman's complaint, Ari Hoffman's complaint against the Seattle Times. He says it's 16 pages, by the way, and he says that they've been bankrolled by Climate Lab and produced content with the exact messaging of the No on 2117 campaign. So he suggests the coverage amounted to what should have been reportable campaign activity under state law. And he names, I want to read this so I don't miss any, he names the Seattle Times, the Seattle Foundation, Clean and Prosperous Washington, Clean and Prosperous Institute, Green Jobs PAC, and the No on 2117 committee. Again, alleging that all those groups failed to disclose the commercial equivalent for all the articles that encourage people to support the No on 2117 campaign. Don't support this initiative. So, according to the Seattle Times, I want to share a little bit more about what Climate Lab is. And this is right off of the Seattle Times page. It says Climate Lab is a Seattle Times initiative that explores the effects of climate change in the Pacific Northwest and beyond. The project illuminates the impacts of heat waves, drought, wildfire, flooding, and examines government and industry actions to help the public better understand how greenhouse gas emissions are changing our lives. Now, I want to note that I reached out today to the Seattle Times, to Seattle Foundation, to Clean and Prosperous Washington, seeking comment on the complaint. Thus far, I've received no response. My article yet to be published, but if in fact I receive a response from them today ahead of publication, I will certainly include any comment from them since they are the ones named in the complaint. Now, Ari Hoffman took note of the fact that last week the Public Disclosure Commission advanced a complaint that was filed last May against Let's Go Washington and Brandi Kruse to what they call kind of the next phase, the formal investigation phase. Makes it seem like the commission believes there could be some merit to the complaint. Otherwise, like many others in the past, they could have just dismissed it or said, really, this thing's a nothing burger and there's nothing to look into. But they are moving forward with it. And after that news came out late last week, a couple of the big TV stations downtown jumped all over it. And before they even reached out to Kruse or Let's Go Washington for comment, since they're the ones named in the complaint, they just ran with the story and went, it almost made it seem like it was a new complaint. And that received a lot of pushback from Brandi Kruse and Brian Haywood of Let's Go Washington. So what happened yesterday when Ari Hoffman came out with his big PDC complaint against the Seattle Times?
I have gotten no response back from them at all. I haven't heard from them at all. And in fact, what's interesting to me is you might remember how breathlessly the media covered the PDC complaint against Brandi Kruse and Let's Go Washington. So far, the only outlets I have heard from today is the Center Square, the Linwood Times, and the Seattle Stranger. I remember people in a certain newsroom that you and I both know very well breathlessly running, oh my God, there's a PDC complaint against Brian Haywood and Brandi Kruse, and we have to cover this right away. Nothing like that here. I haven't heard from any of the TV outlets. I haven't heard from the Seattle Times, probably because they're named in the complaint. But the question is, will they actually even cover this thing as breathlessly as they covered the one against Let's Go Washington and Brandi Kruse?
Okay, so just briefly, again, a little bit more on West's page, a complaint, which is 6 pages. Got ahead of myself there. The PDC complaint against Washingtonians for ethical government. He is alleging that their president, Andrew Villeneuve, he says it's an organization, Washingtonians for ethical government's not a neutral watchdog. He describes it this way. It is a rabid partisan attack dog that weaponizes the PDC and orchestrates media campaigns exclusively against conservative initiatives and their sponsors. And he included multiple examples for asking the PDC to look into them. And we'll put a couple of these up. One of them, he said that, WAFEG's May 12th complaint against Let's Go Washington was personally filed by Pam Stewart. He notes the fact she is a sitting Samama City Council member in her capacity as WAFEG's communications liaison. He asked them to look into whether or not she's using an elected office potentially to expend public resources or lend institutional weight to what is, in substance, opposition research against a political adversary. So again, there are a number, I think he's got like 12 or 14 different exhibits that he included in his 6-page complaint to the PDC. So that was just issued today. Nothing back from the PDC yet. These things don't really have a timeline other than initially after filing 90 days for them to decide if they're going to advance it or not. Although he's asking them to expedite everything right now because, of course, we've got 3 Let's Go Washington initiatives on the ballot this fall. This bad press, as he puts it, for Let's Go Washington, he thinks is unwarranted, and he wants it resolved, basically to clear them of any wrongdoing and to show maybe that Washingtonians for ethical government is not really an unbiased watchdog group as they claim to be. So one more quick clip here from Brian Haywood of Let's Go Washington, because he says the issue of journalists or influencers like Brandi Kruse talking about these issues publicly or in a podcast form like we do here at Washington in Focus Daily, he says this has already been decided in a case years ago that involved KVI talk show hosts Kirby Wilbur and John Carlson. I worked for them at the time. In full disclosure, I worked at KVI at the time, so I was very familiar with this case when it went before the state Supreme Court. So he brought that up, saying there's no reason the PDC should be wasting its time.
And they were supporting an initiative, and they were talking about it on their radio show, and the same machine tried to go after them and say, oh, you don't really, if you're a journalist, you don't really have a First Amendment right to your own opinions. You can't say anything on your show. And it went to court and they won. They're trying that same play now with Brandi Kruse. They're trying to say, well, Brandi Kruse can't have her own opinion. It must be paid. And so the complaint against us, they filed like 159 issues where they said somehow she'd given us something. We got questions from the PDC that said, have you ever paid Brandi Kruse? Our answer is no, we've never paid Brandi Kruse. Let's Go Washington's never paid her for anything. They said, have you ever paid anyone else that has paid Brandi Kruse? And the answer to that is no. And that question is really interesting to me because I suspect the reason we're getting that question is because that's what the other side does. They pay people to do it. So why are they asking us? It had never occurred to me to do that.
So it certainly seems the commission, the Public Disclosure Commission, will be busy with all of this and perhaps more to come, I'm told, in the days and weeks ahead. Obviously, an important election coming up in November, so maybe that's why there's going to be a lot of this going, from either side back and forth, but it will keep the commission busy.